I pulled up the dirt road to my ranch on a Tuesday morning and found 3 people already inside my fence line, not near it. Inside it, an orange violation notice had been zip-tied to my gate post, a legal demand posted on my own property without my knowledge or permission. A woman with a clipboard and sunglasses was walking my perimeter, like she was finishing an inspection she'd already decided the outcome of. A man in a gray suit stood near the barn briefcase at his feet. A third man in khakis paced the fence line with a metal measuring tape, snapping it open every few steps, photographing my outwieldings with his phone. None of them had knocked. I stepped out of the truck. I was calmer than they probably expected. That was intentional. The woman turned when she heard the door. She didn't apologize. She shifted her clipboard and said, "We've been trying to reach you. This land has always been part of our community's holdings. The sale you completed was irregular. We're here to correct the record." She said it like reading a verdict that had already been decided. The man in the suit stepped forward and extended an envelope. Gerald Marsh, representing Quiet Hills Homeowners Association. He named his firm after that one of those partnership names built to sound like a door you don't open from this side. This formally notifies you that this property falls under HOA jurisdiction per a recorded covenant. You have 30 days to cease all activity on the land, or we file for injunctive relief in county court. I took the envelope and opened it. 4 pages on firm letterhead. Dense paragraphs packed with phrases like Superior Interest Historic Development Covenant and Community Adjacent Land Use. Near the bottom, the deadline plain enough beneath all the formal language, 30 days to stop everything or see them in court. I read it twice. There was no document number anywhere in 4 pages, no recording date, no grantor, just language, official sounding language built around a claim that had no anchor in any public record. Marsh stood to the side while I read, hands folded, the practiced stillness of a man paid by the hour. Behind me, the camera clicked again, the storage shed, the corner of the barn, the side gate I'd rehung 2 weekends ago. The woman had moved closer. Late 50s hair, set like she had a dinner after this, and a smile that lived entirely below her nose. She had the particular patience of someone accustomed to sitting across from people and waiting for them to fold. "I'm Patricia Wells," she said, "board president. We're not here to make this adversarial. We're here because this situation needs to be addressed before it becomes something nobody wants to deal with." She gave me a moment to absorb the word nobody. "Miss Wells," I said, "what's the recorded document number for the covenant you're citing?" She tilted her head slightly. "That comes through proper legal channels. I understand legal channels, but a recorded covenant has a document number, recording date, a grantor, and a grantee. Can you give me any of those?" She looked at me the way people look at someone asking the wrong questions. Then the smile returned. "This land has always been part of our community's holdings. The transaction you went through was irregular. We're simply correcting the record before this becomes a larger problem for everyone." The exact same sentence, word for word. She had given this answer before, in this tone, in front of other people, standing exactly where I was standing. It had worked every time. Nobody had asked for a document number. Nobody had gone to the county recorder's office and pulled the original plat. Nobody had checked. I had 3 weeks before any of this. I looked at the man still pacing my fence line. I looked at the orange notice on my gatepost, HOA seal, embossed in the corner, my address printed beneath it like it was already theirs to administer. I told them they were trespassing on private property and asked them to leave. Marsh said they'd be in touch through counsel. Wells said almost warmly that she hoped this could be resolved without going further. The man with the measuring tape pocketed his phone and followed them back to a black SUV parked just off the edge of my driveway. No hurry, no embarrassment. The walk of people who had done this before and gotten exactly what they came for every time. I watched them drive out. Then I walked to the gatepost and pulled the orange notice free. Carried it inside, set it on the kitchen counter next to a manila folder. 2 documents side by side on the same surface, one designed to look like authority. The other actually was. They had just handed me a formal letter claiming ownership of land I had legally purchased, professionally surveyed, and recorded at the county in the whole time. The woman with the clipboard had no idea that the document she needed to win didn't exist anywhere in the public record. What none of them knew, not the attorney in the pressed suit, Not the board president with her patient practice smile, not the man who had spent 20 minutes measuring my fence line as if the answer were already written into it, was what I'd found at the county recorder's office 3 weeks before any of this started. I didn't buy the ranch on impulse. I'd been watching county tax lien auctions for the better part of 2 years, the kind of listings most people scroll past because the properties are overgrown, or the access road needs work, or the previous owner left behind more questions than answers. That's exactly what I was looking for. Something real. Something with land. Something I could put work into without paying someone else's premium for the privilege. The ranch came up in February. 11 acres, a main structure, 2 outbuildings, a working well. The previous owner was an elderly man named Harold Briggs, who had quietly stopped paying property taxes 3 years prior, transferred care to a daughter in another state, and never returned. The county followed its process. The lien acred, the auction was listed. I attended, I bid, I won. The deed was recorded at the county recorder's office within 30 days. Title insurance was issued. Survey was completed. Everything was clean. Everything was documented, and the parcel, I confirmed this before the ink was dry, sat outside the boundaries of the Quiet Hills Homeowners Association. That last part turned out to be the detail that mattered most. I didn't know much about Quiet Hills when I bought the ranch. I knew the subdivision existed 96 homes on a grid of cul-de-sacs about a quarter mile up the road. The kind of planned community built in 3 phases across 2 decades and held together by monthly dues and a rulebook that got longer every year. I drove past the entrance sign on the way to my own gate. That was the extent of my relationship with them. Then I met my neighbor. Ray Kowalski had lived 2 streets inside Quiet Hills for 22 years. He introduced himself 2 weeks after I moved in, came walking down the road on a Saturday morning with his hands in his jacket pockets. No particular pretense about the visit. Just a man who had been watching the abandoned ranch for years and wanted to see who finally bought it. He sat at my kitchen table and didn't waste much time getting to the point. "You know who Patricia Wells is?" I didn't. He nodded slowly, like that explained something. Patricia Wells had been board president of Quiet Hills HOA for 11 years. In that time, she had run the community with the efficiency of someone who genuinely could not identify the boundary between governance and personal dominion. 96 homes, $380 a month in dues. A rulebook now 47 pages long, updated every January. Always expanded, never condensed. Grass over 4 inches triggered an automatic notice. Mailbox colors required pre-approval from a specific committee that Wells chaired. Holiday lights came down by January 15th, or the fine started at $50 and doubled weekly. "She have an enforcement history?" I asked. Rye laughed, the short kind without humor. "She has 2 attorneys on retainer," he said, "and a collections company that handles the liens. She's foreclosed on 2 properties in the last 5 years. Not because people couldn't pay, because she could. The community lived inside a low-grade permanent apprehension. Nobody parked a boat in their driveway without calculating the risk first. Nobody painted their shutters without checking the approved palette. 2 people had tried to run against Wells in board elections over the past decade. Both of them received violation notices within 3 weeks of filing their candidacy paperwork. Code violations, documentation issues, suddenly urgent maintenance concerns. Nobody could prove the connection. Nobody tried anymore. Then Ray told me about the lot on the western boundary. 3 years before I arrived, a vacant parcel on the far edge of the subdivision had sat unsold for nearly 4 years. It wasn't inside the HOA boundary, not officially, but it was adjacent, and Wells had apparently decided that adjacency was close enough to jurisdiction. She started mowing it, posted HOA signage on the fence, sent a letter to the county assessor describing it as community-maintained property. When the lot finally sold, the new buyer went through the standard permitting process. Somewhere in that process, they received a letter from the HOA's property management company, informing them that, per a community development covenant, they were required to pay a covenant recognition fee of $6,000 before the county would process their permit. The buyer called the county. The county said they had no record of any such requirement, but that HOA documentation sometimes ran on a separate track. The buyer didn't push further. They paid the $6,000. They just wanted to start building. Wells considered that a precedent. Rye said he'd kept copies of some of the letters from that period, not because he thought he'd ever need them, just because something about the whole thing hadn't sat right. He also remembered that Wells had brought the western boundary question to a formal board vote had it minuted, and had the property management company send the fee demand on official letterhead, everything properly documented on her end. The irony of that, the person running a scam making sure her own paperwork was in order, wasn't lost on me. How many times has she done that I know of? Twice. Once on the western lot, once on a garage conversion somebody tried to do on the north side. Different mechanism, same result. Pay up or get buried in paperwork until it hurts more than the money. I thought about that. 11 acres. An auction. Wells's people hadn't caught in time. A developer, Ray mentioned this carefully, almost offhandedly, who had been connected to the board for about 2 years and had made some informal inquiries about the ranch before it went to auction. He didn't know the details. Just that there had been some interest, some conversations at board level, and then the auction had moved faster than expected. I didn't say anything for a moment, so that's what this is. They'd had their eye on this land. The auction slipped past them. Now they were trying to recover through paper what they'd missed at the county clerk's window. The mechanism was the same one that had worked twice before. Formal language official-looking documents. The patient assumption that the person on the other side would find it easier to pay than to fight. I walked Ray out to his car when he left. He stopped at the gate and looked at the post where the orange notice had been zip-tied that morning. "What are you going to do?" he asked. "Research," I said. He nodded, got in his car, and drove back toward the subdivision. I watched him go, then looked out across the 11 acres behind me. The dry grass, the fence line, the outbuildings still holding their shape after years of nobody looking after them. Nobody had pulled the original plat on this land, not the previous buyer on the western lot, not the garage conversion owner to the north. Nobody had sat in the county recorder's office and looked at what was actually on file. I already had, but I wasn't done yet. The morning after they came to my property, I called a real estate attorney. Not because I was panicking, because I wanted to understand exactly what I was dealing with before I responded to anything in writing. There's a difference between knowing your right and knowing how to use it, and that difference is usually the thing that determines how a situation ends. His name was Dennis Carver. He'd handled property disputes in this county for 19 years. I sent him the HOA's letter before our call and gave him 20 minutes to read it. His first question: "Did they give you a recorded document number for this covenant?" Number, a pause. Then the claim is hollow at its foundation. A covenant that isn't recorded in the county's public records doesn't bind a subsequent purchaser. You bought with a clean title search. They can't enforce something that isn't in the chain of title. That was the good news. The bad news, Carver said, is that hollow doesn't mean harmless. They can still file motions. They can still make noise. If they go as far as a list pendants, they can freeze your title without proving anything yet, just by asserting a dispute exists. The process itself becomes the weapon. Some people pay just to make it stop. I told him I wasn't going to pay anything. "Then get your document request in writing," he said. "Today ask them formally for the recording information." Every day they can't produce it is a day the record shows they knew their claim had no foundation. I drafted the letter that afternoon. 3 paragraphs, no flourish. I identified myself as the recorded owner of the parcel, referenced their letter and its assertions, and formally requested the following. The document number of the historic covenant cited its recording date and the names of the original grantor and grantee. I gave them 10 business days to respond and sent it certified mail to Gerald Marsh's firm. Then I waited. Marsh responded on day 9, not with a document number, with a longer letter, 4 pages this time, versus the original 4. Though the additional length had done nothing to improve the quality of the underlying argument, the new version introduced terminology that hadn't appeared before: adverse possession, interest community reliance doctrine, decades of maintained boundary understanding. Each phrase landed in the letter with the confidence of something that sounded like law without quite being it. One passage near the middle informed me that effective immediately I was required to submit any and all development plans for the ranch to the HOA board for review and written approval prior to commencing any improvement, modification, or construction on the property. Failure to comply would result in a fine of $500 per day assessed from the date of this letter. $500 per day. I read that paragraph 3 times, not out of alarm, out of something closer to professional respect for the audacity. Marsh had pivoted cleanly from "we own this land" to "you need our permission to use your land," without ever supplying a single recorded document to justify either position. The claim had grown more aggressive in direct proportion to its evidentiary weakness. There was still no document number anywhere in 4 pages. I set the letter down and was considering how to respond when my phone rang. Quiet Hills HOA prefix, Patricia Wells. She called without the attorney present, which was its own kind of information. Her tone was different on the phone than it had been in person. Less clipboard, more fireplace. Warm and patient in the way of someone who has had this exact conversation before and found the right register for it. She said she wanted to reach out personally because she believed these things were best handled between reasonable people before they became something neither side wanted. I said I was listening. The previous owner, Harold, had an understanding with the community that went back a long time. She said it was never put in writing, but it was universally acknowledged. The ranch was always considered part of the larger community character. What we're trying to do is formalize what was always understood to be true. Community character first time. I understand that you went through a proper legal process. With the purchase, she continued, we're not disputing that. We're simply saying that the legal transaction didn't account for the existing community understanding, and we'd like to work with you to find something that honors the community character of the area. Community character. Second time, Miss Wells, I said, is there a written record of this understanding Harold had with the HOA? Anything signed, anything in a meeting minutes, anything recorded with the county? A brief pause. These things were handled informally, which is part of why the current situation is complicated. So there's no written record. There's a deep history of community character here. Community character? Third time. And I think you'd find that most people in your position find it easier to work with us than to let this become something prolonged and expensive. We're not unreasonable people. We just want what's right for the community. I thanked her for calling. I told her I'd be in touch through counsel. I ended the call. I sat with the phone in my hand for a moment. She was describing an informal understanding that may have existed between Harold and a neighbor. It may have been real. It may have been invented entirely after the auction. It may have been something Harold had agreed to informally years ago and forgotten about by the time he left. But it didn't matter, because an informal understanding between a previous owner and a private HOA, never reduced to writing, never recorded, never attached to the deed, was worth exactly nothing against a clean title. That's not an opinion. That's property law. The week after Wells called, I found out through Ray that the HOA had held a special board session. Closed meeting members not invited. The board voted 4-1 to formally pursue what their minutes described as the reclamation of community-adjacent property interests. The motion passed. It was officially documented. Those minutes would matter later. I added them to the folder on my counter. The lawyer sent back a 4-page letter. Not one page of it contained a document number. The county recorder's office opens at 8 o'clock in the morning. I was there at 8:03 on a Monday, and I came back 4 days in a row. I wasn't looking for anything complicated. I was looking for what was actually on file, the documents that had been sitting in public records since before any of this started available to anyone who walked in and asked. Most people never do. Most people assume that if someone sends them a letter on official letterhead citing a legal instrument, that instrument must exist. That assumption is where Patricia Wells had built her entire operation. I came in with a list. 3 things. The original plat for the Quiet Hills subdivision, the HOAs, recorded founding documents, and the full tax parcel history for my land. Public record, no subpoenas required, no attorneys needed, just a request form and a copy fee. The plat came first. It was recorded 43 years ago when the developer originally subdivided the land and registered the Quiet Hills community with the county. Large format paper, the kind that takes both hands to unfold properly, covered in surveyor's lines and parcel numbers and boundary notations in faded ink. I found my parcel in under 2 minutes. There was a solid black line running along the eastern edge of the subdivision, the HOA's declared boundary, drawn by the original developer and recorded with the county at the time of formation. Inside that line, the 96 residential lots of Quiet Hills, each labeled, each numbered, each part of the community as legally defined. Outside that line, clearly separated with its own parcel number printed in the same surveyor's hand. The ranch not adjacent in any ambiguous sense, not a gray area. The boundary line was drawn, and my land was on the other side of it. The plat didn't offer an opinion about this. It didn't argue. It just showed what had been true for 43 years. I asked the clerk for a certified copy stamped and sealed. She had it ready in 20 minutes. I rolled it carefully, slid it into a tube, and set it next to my bag. That was the main piece. Everything else I found that week was supporting material, but it was good supporting material. The HOA's Articles of Incorporation, recorded when the community was formally established, contained a geographic description of the association's jurisdiction. It listed the subdivision boundaries by meets and bounds. It referenced specific lot numbers. I read through the full description twice, slowly looking for any reference to the ranch parcel number. It wasn't there. Not in the main text, not in an addendum, not in any amendment filed in the 43 years since. The ranch parcel number had never appeared in Quiet Hills HOA's own founding documents, the ones they had filed themselves in their own name with the county. Tax records were next at the county assessor's office 2 floors up. Every parcel in the county carries a tax parcel identification number, a PIN that links it to a specific assessed owner and tax lot. I asked for the parcel history on my land going back to the subdivision's formation. The assessor's office pulled it while I waited. The ranch had carried its own separate PIN for the entire history of the subdivision, 43 years of individual assessment. It had never been co-assessed with any HOA lot, never merged, never administratively linked to Quiet Hills in any way. The assessor's office would provide written confirmation of that on request, the clerk told me. I requested it on the spot. She said it would be ready by end of week. I added that to the list. On Thursday afternoon, I drove to Ray Kowalski's house. He'd mentioned in our first conversation that he'd kept copies of the correspondence from the western boundary situation. The vacant lot Wells had slowly annexed the new buyer who'd paid the $6,000 fee. I'd been thinking about those letters all week, not because I needed them to prove my own case. The plat did that on its own, but because a pattern of conduct is a different kind of evidence than a single incident. It doesn't just prove one claim. It shows how someone operates. Ray had them in a manila envelope in a filing cabinet in his spare room. He'd kept them the same way someone keeps an insurance policy, hoping never to need them, but unwilling to throw them away. He handed the envelope across the kitchen table without ceremony. "I should have done something with these when it happened," he said. "You're doing something with them now," I told him. The letters documented everything. The HOA's initial contact with the buyer, the property management company's demand for the $6,000 covenant recognition fee, and most importantly, the HOA's own internal correspondence referencing the western lot as a test case for boundary normalization. That phrase in their own words in a letter they had written and sent. I drove home with the envelope on the passenger seat. That evening, I laid everything out on the kitchen table. Plat map certified and stamped, HOA, Articles of Incorporation boundary description, highlighted tax parcel history, the assessor's written confirmation which had arrived by email that afternoon, Ray's envelope, Marsh's 2 letters, Wells's certified mail notice, the board meeting minutes Ray had described to me, which I'd also pulled from the county's recorded HOA filings that afternoon. I organized them in order labeled, each one put the plat in the front. They were counting on the fact that most people don't know what a plat map is, let alone where to find one. They had run this play before twice, and both times the person on the other end had paid rather than looked. It was a reasonable assumption, statistically speaking. I closed the folder. I hadn't played any of it yet. The call came from my title insurance company on a Wednesday morning. I was out at the ranch repairing a section of fence along the north perimeter when my phone rang. The woman on the line was professional, apologetic in the way that people are when they're delivering news they didn't create. She said they needed to notify me as a matter of policy. A list pendants had been filed against my property that morning by the law offices of Gerald Marsh on behalf of the Quiet Hills Homeowners Association. I asked her to spell it out for me in plain terms. It's a notice recorded in the county's public property records. She said it formally announces that someone is claiming a legal dispute over your land. Once it's on file, it attaches to your title. Any bank, any buyer, any contractor doing a title search will see it. Until it's removed, you can't sell the property, can't refinance, can't pull development permits. I stood there at the fence line with the phone against my ear and the October wind moving through the dry grass around my boots. How long does it stay on file until the court orders it removed or the filing party withdraws it voluntarily? I thanked her and ended the call. I looked out across the 11 acres for a moment, the barn, the outbuildings, the fence line that man had been measuring the morning. They walked in uninvited. All of it still mine legally, but now carrying a notice in the public record that told the entire world a dispute was in progress, that the ownership wasn't clean, that anyone who wanted to do business with this land should think twice. They had frozen it without a single recorded document to support their claim. Without a document number, without a grantor or a grantee or a recording date for the covenant they kept citing, they had walked into the county recorder's office and filed a list pendants and locked my title. The process was the weapon. Carver had told me exactly this. I called him before I got back in the truck. His assessment was precise and controlled the way his assessments always were. The list pendants was procedurally permissible as a preliminary filing. The bar for filing one is low, deliberately so. But the critical question, he said, was whether the underlying claim had any basis in recorded public documents. If it didn't, and we both knew it didn't, then the filing was potentially actionable as slander of title. That's a tort. Real damages, not theoretical ones. Attorney's fees cost compensation for the financial harm caused by the clouded title. Can we get it removed, I asked. We can challenge it, but that takes time and motion practice, which is exactly what they're counting on. They want you to calculate that fighting costs more than settling. I told him to start preparing the challenge paperwork. I wasn't settling. 3 days after the list pendants landed, Marsh sent another letter. This one had a different tone, less adversarial, more transactional. The HOA, it said, was prepared to offer a resolution. If I paid a one-time covenant recognition fee of $14,500 and agreed to submit all future development plans to the HOA board for written approval, the association would withdraw the list pendants and consider the matter closed. The letter described this arrangement as generous. It used the phrase expedient resolution for all parties twice and reminded me in the second-to-last paragraph that prolonged litigation and property disputes could take 3 to 5 years and cost both sides considerably. I read it once and set it down $14,500. The Western lot buyer had paid $6,000. That was 3 years ago. Wells had apparently adjusted for inflation or had simply decided that 11 acres and a man who'd already asked the right questions was worth a higher number. The mechanism was identical. No recorded document, no legal basis, just a formal-looking demand, and the implicit message that the paperwork around you would keep multiplying until it hurt more than the payment. I thought about the buyer who had paid the $6,000. I thought about what Rye had said, that he'd called the county, been told there was no such requirement, and paid anyway. He just wanted to start building. I understood that after months of letters and calls and certified mail and legal fees mounting on both sides, the idea of writing a check and making it stop must have felt like oxygen. But paying meant the next person paid too, and the one after that. I went back to my kitchen table that evening. The folder was still there. Plat map on top, certified and stamped articles of incorporation with the boundary description, highlighted tax parcel history. The assessor's written confirmation raise envelope with the western boundary letters and the phrase boundary normalization in the HOA's own handwriting. I also pulled up the HOA's bylaws on the county's recorded filings database. Quiet Hills HOA, per its own governing documents, was required to permit any member of the community to request a formal dispute resolution meeting open to the full membership, not just the board when a matter involved association-claimed property interests. I was not a member of Quiet Hills HOA. My land was not in their jurisdiction, but Marsh had filed the list pendants claiming it was, which meant by their own legal theory, I had standing to invoke their own bylaws. I drafted the request that night. Formal letter to Gerald Marsh copying the HOA board. I declined the settlement. I invoked the dispute resolution provision. I requested a meeting open to the full Quiet Hills membership, not a closed board session, within 30 days. I stated that I intended to present documentary evidence relevant to the association's claim and that I believed the membership had a right to see it. I sent it certified mail the next morning. Carver called me that afternoon after I forwarded him a copy. "You're bringing this in front of the whole community?" He said they built their credibility inside that community. I said that's where it should come apart. There was a pause on the line. "Make sure your folder's organized." He said it already was. They had frozen my land with a document. I was going to unfreeze it with a better one. The HOA sent the meeting notice to all 96 homeowners on a Thursday. The subject line read, "Calm Community Information Session Protecting Quiet Hills Neighborhood Integrity." The body was 3 paragraphs of measured language about community character, historic land interests, and the association's ongoing commitment to protecting property values for all residents. It did not mention my name. It did not mention the list pendants. It did not mention the lawsuit threat or the $14,500 settlement demand. It mentioned community character twice. The meeting was held on a Tuesday evening in the Quiet Hills Clubhouse, a low rectangular building at the center of the subdivision with folding chairs, fluorescent lighting, and the faint smell of the last potluck that had been held there. I arrived 7 minutes early. Approximately 60 residents were already seated or finding seats when I came in. I took a chair in the second row slightly off-center and set my manila folder flat on my lap. Nobody from the board acknowledged my presence. Patricia Wells stood at the front of the room beside a projection screen. She was dressed for this not formally but deliberately the kind of outfit that says, "I'm a neighbor just like you," while also saying, "I run things here." Gerald Marsh sat in a chair along the sidewall, one leg crossed over the other, a leather portfolio on his knee. He didn't look at me when I came in. The other board members sat in a row at a folding table to Wells's left. 4 of them. One, a younger man named Davis, who had been on the board for about 18 months, had a printed agenda in front of him and the slightly too eager posture of someone who hadn't been briefed on everything but wanted to be helpful. Wells began at 7 o'clock exactly. She was good at this. I'll give her that without hesitation. She had the voice of someone who had run 100 of these meetings. Warm, authoritative, never rushed, never defensive. She opened by thanking everyone for coming and acknowledging that some members had questions about recent activity concerning a property adjacent to the community. She said the board wanted to be transparent and wanted everyone to have the full picture. The full picture as she presented it went like this. When Quiet Hills was originally developed, the ranch parcel had been understood by all parties as part of the community's broader land interest. Over time, due to a clerical irregularity during a property transfer, decades ago, the parcel had become separated from the HOA's formal administrative records. The association had recently become aware that the parcel had been sold at a county auction without proper account being taken of the community's existing interest. The board had engaged legal counsel to correct this historic error. They were not trying to take anything from anyone. They were simply ensuring that the community's founding vision was honored. She showed a map on the projection screen. It was clean and well-designed, the kind of thing you make in a mapping program with a few hours in a subscription. The Quiet Hills subdivision in light blue. The ranch parcel in a slightly different shade of blue sitting adjacent, practically touching. The visual implication was obvious. These two things belong together. They always have. She did not show a plat. She did not show a recorded document number. She showed a map she had made herself. For the first 15 minutes, the room was with her. I watched it happen in real time, the slow nodding, the concerned expressions, the 2 or 3 residents near the front who asked clarifying questions that Wells handled smoothly and redirected back to her central message. These were people who had lived in this community for years under the assumption that the board handled legal matters competently and in good faith. They had no particular reason to doubt her. Most of them had never pulled a plat map in their lives. I sat in the second row and said nothing. I held the folder flat on my lap and listened. The first crack came from the back of the room. A man I didn't recognize, older, with the unhurried manner of someone who had been through enough meetings to know when something wasn't adding up, raised his hand and waited until Wells acknowledged him. "Patricia," he said, "you mentioned a recorded covenant. What's the document number? I'd like to look it up at the county." The room didn't go quiet exactly, but something shifted in the air. Wells smiled. The same patient smile I had seen on my property the morning all this started. The documentation around the original covenant is complex. She said it involves historic informal understandings that predate the current recording system. Our legal team is working through the specifics, so there's no document number. The man said there is a body of supporting evidence that our attorneys are compiling. That's a no, he said, and sat back in his chair. 3 people in the row ahead of him exchanged a look. Wells moved on without pausing, which was the right tactical decision. She pivoted to property values, to the importance of community continuity, to what it would mean for the neighborhood if an 11-acre parcel adjacent to the subdivision were developed without regard for community standards. That's when Davis leaned forward. He was trying to help. He had the energy of someone who wanted to contribute something useful and had been sitting quiet for too long, he said. And I am certain he had no idea how it landed. The timeline is important here too, because if we're going to accommodate the development proposal, there's a window that the developer needs. Wells cut him off so fast, the sentence was still in the air when she talked over it. What Tom is referring to is the timeline for our internal review process, she said smoothly, which is standard procedure for any adjacent property matter, but she had been half a second too slow. Several heads had turned toward Davis. One woman near the middle of the room leaned over and said something quietly to her husband. The man in the back who had asked about the document number was watching Wells with an expression that had moved past skepticism into something more settled. I kept my face neutral and made a note on the inside cover of my folder. The meeting ran another 20 minutes. Wells recovered her footing. She was experienced enough to know how to re-enter a room, and by the time she opened the floor for final questions, the energy had stabilized into something more uncertain than hostile. Not a rout, not a victory, just a room full of people who had arrived, trusting and were leaving with questions they hadn't expected to have. When Wells asked if there were any final comments, I raised my hand. She hesitated for exactly 1 beat before she called on me. I stood up. I did not take the folder with me to the front. I stayed where I was, second row, and I asked 2 questions. The first, has anyone in this room, any homeowner, any board member, anyone ever seen the actual recorded document that creates this covenant? Not a summary, not a letter from an attorney, the document itself with a recording date and a document number. Silence. I let it sit for a moment. The second question I said, has the board ever produced a plat map? The original subdivision plat recorded with the county showing this parcel within the HOA's declared boundary. The silence this time was a different kind, not just the absence of an answer, the absence of even the attempt at one. Wells began to say something about proper legal channels and appropriate forms for documentary review. I nodded politely and sat back down. She moved to close the meeting. Standard closing language. Thank you for coming. The board takes its responsibility to the community seriously. More information would be forthcoming through counsel. I waited until she finished. Then I stood again and I set the manila folder on the folding table at the front of the room. I did not open it. I'd like to schedule a follow-up meeting, I said. Open to the full membership. I have some county records I think the community deserves to see. I set the folder on the table in front of me. Karen stopped mid-sentence. She recognized what a manila folder from a county recorder's office looks like. The weight of it, the dimensions, the kind of thing you only carry if you've spent time with public records. And for the first time all evening, she looked like someone who wasn't sure she had already won. The room went home with questions. I went home with the folder. The follow-up meeting drew more people than the first one. I counted 73 residents when I arrived. Some of them I recognized from Tuesday's session. Others were faces I hadn't seen before, people who had heard something afterward in driveways and text messages and over back fences, and had decided they wanted to be there this time. Ray Kowalski was near the back third row from the wall. He gave me a short nod when I came in. Gerald Marsh was already seated along the sidewall. Different suit, same leather portfolio, same careful neutrality on his face. He had the posture of a managing his exposure. Patricia Wells and the full board were at the front table. Davis, the one who had slipped about the developer timeline, was staring at the printed agenda in front of him. Wells looked composed. She had had 2 weeks to prepare for this, and she looked like she had used them. I sat down, set the folder on the table in front of me, and waited. Wells opened the meeting with a brief statement. The board appreciated the community's engagement. They remained committed to transparency. They welcomed the opportunity to continue the dialogue. Then she yielded the floor to me. I stood up. I didn't go to the front of the room. I stayed where I was, folder in hand, and I spoke to the room the way you speak when you don't need a microphone. I want to show this community 3 documents, I said. All of them are public records. All of them have been sitting at the county recorder office since before most of us moved here. Anyone in this room could have pulled them at any time. I unrolled the plat map on the table. Large format certified copy county seal stamped in the lower right corner. 43 years old, I held it up so the room could see it, and I pointed to 2 things. This line, I said, tracing the solid boundary along the eastern edge of the subdivision, is the HOA's declared boundary recorded by the original developer. When this community was established, it has not been amended, it has not been updated, it has not moved. I moved my finger 2 into the right. This parcel labeled with the same lot number that appears on my deed sits outside that line. It has sat outside that line since the day this plat was recorded 43 years ago. The room was quiet in the way rooms get when people are recalibrating. I set the plat down flat on the table so it remained visible. Wells started to speak. The plat doesn't account for the subsequent community understanding. Miss Wells, I said, I'd like to finish. She stopped. I opened the HOA's Articles of Incorporation, their own founding document filed in their own name with the county at the time of formation. I read the boundary description aloud, every lot number listed, every parcel identified as part of the HOA's declared jurisdiction. If anyone hears the ranch parcel number, I said, please stop me. I read the full description. No one stopped me because it wasn't there. Not in the main text, not in any addendum, not in any amendment filed in the 4 decades since. The ranch parcel had never appeared in Quiet Hills HOA's own founding documents. The silence that followed was not empty. It was the sound of 73 people arriving at the same conclusion at the same time. A woman 2 rows back said quietly but clearly, "It's not in there. It has never been in there," I said. I looked at Marsh. He was looking at the plat map. I set the Articles of Incorporation next to the plat. Then I placed the county assessor's written confirmation on top 1-page official letter, head stating that the ranch parcel had carried its own separate tax identification number for the full 43-year history of the subdivision and had never been co-assessed with any HOA property. No covenant of any kind appeared in their records affecting the parcel. 3 public documents, I said. The plat that shows the boundary, the HOA's own articles that describe their jurisdiction, and the county's written confirmation that no covenant exists in their records. I paused. The HOA sent me a legal letter claiming this land has always been part of their community's holdings. They filed a list pendants against my title, a document that froze my ability to sell, to refinance, or to pull a single building permit based on that claim. I asked their attorney in writing 6 weeks ago for the recorded document number of the covenant they were citing. I picked up Marsh's response letter and set it on the table. This is what he sent back. 4 pages. No document number. The room shifted. Not loudly, not with shouting, but in the way a room shifts when the floor is actually moved. People straightening in chairs, looking at each other, looking at the board table, looking at Wells. Ray Kowalski stood up from the 3rd row. He didn't ask for the floor. He just stood and the room let him have it because he was a man who had lived there for 22 years and everyone knew his face. "I want to tell you about a vacant lot on the western boundary," he said. 3 years ago, he described the whole thing. The gradual maintenance creep, the HOA signage, the $6,000 covenant recognition fee extracted from the new buyer. The buyer who had called the county, been told there was no such requirement and paid anyway because he just wanted to start building. How many people in this room, Ray said, have paid a fee to this board that you couldn't find a recorded basis for a beat of silence? Then 3 hands went up. Not quickly, not with anger. Slowly, the way people raise their hands when they're not sure they want to admit something in public, but have decided it matters more than the embarrassment. The room changed temperature. Wells stood. She put both hands on the table, and she said in the voice that had run 100 of these meetings, "This is a matter of community interpretation of a complex, historic, Where's your document number? Patricia, the man from the back row, the one who had asked the same question 2 weeks ago. Same unhurried voice. First name this time. Wells looked at him. She looked at the plat map still spread on the table. She looked at the three people with their hands still partially raised. She didn't finish her sentence. Marsh uncrossed his legs. He set the portfolio on his knee and opened it for the first time all evening. He spent a long moment looking at whatever was inside it. Then, he leaned toward the board president and said something at a volume designed not to carry. It carried. I need to review the filing posture of the current litigation. The woman next to her husband in the middle row said audibly, "What does that mean?" It meant the lawyer had just told his client in front of 73 of her neighbors that he was no longer certain he could defend the claim. I let the room have that moment. Then I stood and addressed the full membership the same way I had addressed the table. I've forwarded all of these documents to my real estate attorney. I said, I've authorized him to file for immediate release of the list pendants and to evaluate a claim for slander of title against the association and the individual board members who voted to authorize the filing. I looked at the board table. 4 faces. Davis had stopped looking at his agenda. The board meeting minutes from the special session that authorized the list pendants, I said, are also part of the county's public record. They name each member who voted yes. I closed the folder. That's all I have. I sat down. The room did not explode. It didn't need to. The conversation that started in that room in low voices in the parking lot in text messages sent before people reached their cars was going to do what rooms like that do when something true has been said in them. Patricia Wells did not look at me when I sat down. Gerald Marsh was already on his phone. Gerald Marsh filed the withdrawal of the list pendants 9 days after the community meeting. No explanation accompanied the filing. No statement, no letter, no phone call to Carver's office to discuss terms. Just a 1-page document submitted to the county recorder's office withdrawing the association's notice of pendency of action on my parcel. Carver forwarded me the confirmation by email on a Thursday morning. He wrote 3 words in the body of the message. It's been lifted. I read it twice, set the phone down, and went back to what I was doing. The county recorder's office sent written confirmation 4 days later, standard processing time. The cloud on my title had been removed. My parcel was clean again in the public record the same way it had been cleaned the day I bought it before any of this started. That same week, Carver sent a formal demand letter to the HOA's attorneys on my behalf. It identified the list pendants as having been filed without a bona fide recorded legal basis, documented the financial harm caused by the title, freeze delayed permits, professional fees, survey costs, and cited the prior Western Boundary cases as evidence of a pattern of conduct. The letter named the individual board members who had voted to authorize the filing. It put a number on the damages and gave them 30 days to respond. They responded in 22. The settlement was confidential in its terms, as these things usually are. What I can say is that my legal costs were covered, the survey expenses were covered, and the 3 residents who had raised their hands at the community meeting, the ones who had paid covenant recognition fees to this board over the past several years with no recorded legal basis, received full refunds. I know because Rye called me when his neighbor got her check. Around the same time, the county attorney's office opened a preliminary inquiry into whether the list pendants had been filed in violation of state recording statutes. I was not a party to that process. I provided documents when asked and otherwise stayed out of it. The developer whose timeline Davis had accidentally mentioned in the first meeting quietly withdrew from any association with the HOA's land claims. His name stopped appearing in connection with the ranch. I never heard from him directly. 6 weeks after the community meeting, Quiet Hills HOA held a special election. Patricia Wells did not run. 2 of the 4 board members who had voted to authorize the IS pendants also declined to stand for re-election. The 3rd ran and lost by a margin that Ray described to me as not close. A new interim board was seated, and within 2 weeks, they issued a written statement to the full membership, acknowledging that the boundary enforcement actions of the prior administration had not been supported by recorded legal documentation. It was measured language, careful language, the kind of language written by people trying to draw a line between then and now, but it was in writing distributed to all 96 homeowners, and it said what it needed to say. Rye called me after the statement went out. He seemed lighter than he had in any of our previous conversations. The way people sound when something they've been carrying longer than they realized has finally been set down. He told me he'd framed a copy of the plat map, hung it in his entryway. First time in 4 years, I don't feel watched when I checked my mailbox, he said. I told him I was glad. I started working on the ranch in earnest that fall. Not because the legal situation had been waiting on that I could have started earlier technically, but because there's something about finishing a thing properly before you begin something new. The north fence went up first, then the main structure interior worked, the kind of project that takes weekends and patience and doesn't look like much until suddenly it does. One afternoon, I was clearing out the kitchen moving boxes, reorganizing what I'd stacked on the counter when I first moved in. And I found the orange violation notice at the back of a drawer, still crisp, HOA seal in the corner, my address printed underneath it, the date stamp from the morning they had zip-tied it to my gatepost and walked my property like they already owned it. I carried it outside. I walked the fence line, the same perimeter that man had paced with his measuring tape, snapping it open every few steps, photographing my outwieldings with his phone. The fence was solid now, properly set, the posts straight. The land looked like what it was, somebody's property cared for with work still ahead of it and time to do it. I stopped at the gatepost. I looked at the orange notice in my hand for a moment. Then I pinned it back to the post right where they had put it, looked at it once. Then I went back to work. I didn't need to win loudly.